to this month's communication Zoom-torial with the National Grange. It's great to see a lot of familiar faces signing on and some new faces as well. Tonight's meeting is going to be led by our new friends at the US Patent and Trademark Office. But before we get too far in, I just have some reminders of upcoming dates for you all. Our next issue of Good Day Magazine is sitting at the printer right now. So if you're not subscribed, although I think all the people that I can see or know right now are subscribed. So, hey, but if you're not, please visit nationalgrange.org/goodday to subscribe, renew your subscription, or buy a gift subscription for a friend, because why not? Next would be October 10th, which is our next Membership Matters meeting with Amanda Brzana Rios. Then October 15th is the deadline for submitting nominations for Grange Foundation board members. I was asked to tell you all that. If you need information about that, shoot an email to me or to Joan Smith, the foundation chair, and we can give you information on how to put in your application. And then October 20th is the end of our general registration period for this year's National Grange Convention. After that, the price goes up $5 for your registration, and but you don't want to do that, so get in on your general period. And then National Session is, of course, November 14th through 18th in Niagara Falls. So I know many of the faces that I see on will be there. But if you're not planning to be there, tell me why, and then sign up anyway. So we hope to see you all in Niagara this fall. But now the reason that you're all actually here is not to hear me, but to hear our special guests tonight. So I'm going to start by introducing Elizabeth Dougherty from the US Patent and Trademark Office.
Well, thank you, Brian. Brian, I'm looking at my colleague, Brian. Thank you, Philip. What an auspicious beginning. Thank you so much for having the U.S. Patent and Trademark on this evening. So good evening to all. It is a pleasure. We welcome this opportunity to engage with the membership of the National Grange. We're excited for this first step of what we hope will be many in building a strong and fruitful collaboration between the National Grange and the U.S. Patent and Trademark Office, America's innovation agency. Invention, innovation, and entrepreneurship are all features deeply embedded in the success of America and in each and every hometown, small town, and large city across our great nation. The National Grange began its trajectory in 1867 in Washington, D.C., only a few streets over from one of the earliest homes of our agency, known as the Temple of Invention. We began our work in 1790 with the passage of the first Patent Act and the issuance of the first U.S. patent. And we have issued over 11 million patents ever since and are continuing to do so. It is exciting to see our paths, that of the National Grange and the U.S. Patent and Trademark Office, come into close connection yet again. Tonight, I'm thrilled to introduce my colleague Sahar, a scientist, a U.S. patent examiner, and a program manager for the USPTO's Access Program. Sahar will introduce our colleague and tonight's speaker, Brian Yee. I sincerely hope you find tonight's content useful as we welcome over the next weeks, months, and years to share more about the role and importance of intellectual property, especially in starting, building, and growing a small business. We are here to help, we are here to listen, and we are here to act. So my team and I look forward to seeing you all in Niagara Falls this November. With that, I'd like to turn it over to Sahar.
Thank you very much, Elizabeth. It is a pleasure to be here with everyone. As Elizabeth mentioned, I'm the program manager for Access PTO. Just a brief synopsis of what it is. Access works with national organizations such as the Grange, whose focus is not specifically on intellectual property, but whose members include inventors and entrepreneurs that can benefit from knowing how to protect their ideas and creations. And so we evaluate members' needs and create tailored outreach programs such as the program tonight to open the door on knowledge about patents, trademarks, and copyrights like this evening. And, you know, these days we see a lot of images on the internet. How do we know if it's okay to repost an image as if it's your own, or even yet print the material? And how can we use copyrighted material legally? We're very fortunate to have our own Brian Gay from the USPTO help us get answers to these questions. A brief introduction. Brian received his bachelor's in government from Cornell University and his JD from University of Texas at Austin School of Law. Brian serves as an attorney advisor on the copyright team in the USPTO's Office of Policy and International Affairs. He follows developments in local copyright regimes and serves as a resource for interagency teams working on projects affecting Southeast Asia and South America. Brian's also part of the U.S. delegation for meetings of the Standing Committee on Copyright and Related Rights at the World Intellectual Property Organization. And he also contributes to the USPTO's copyright analysis and domestic litigation, legislation, and other policy initiatives. And it is my pleasure to introduce Brian this evening. Brian, welcome. Without further ado, the floor is yours.
Okay, great. Thank you so much, Sahar and Elizabeth, and thank you to the Grange for inviting us. And good evening. I do hope this is the start of a very good collaboration between our agency and your organization. And it's our intent to try to provide, this kind of a service for educating your members with information about intellectual property. I will admit that that I often give presentations on copyright basics and like a more formal copyright training program that covers like the big scope about like, what rights are involved with copyright, how you can register them and how you can sue for them and all this kind of stuff. And a subset of that presentation deals with like the user side of things, which is like how can you use copyright material and how can you rely on certain doctrines like fair use and other kind of exceptions or limitations or licenses that allow the public to access and reuse other people's copyrighted materials. So I'm going to try to take portions of my previous presentations on this topic, but maybe try to tailor it to, I think, what I understand is maybe the focus of some of your questions about copyright. Before I do begin, I just want to also make clear that, and I don't know if anyone is really thinking about this, but as you can see from our agency title is the U.S. Patent and Trademark Office, and nowhere in there is the word copyright. And that's because we actually have the United States government has a different agency, a separate agency. It's a sister agency of ours called the U.S. Copyright Office. And they have that agency is a specialized agency, just like ours, that is dedicated solely to copyrights, the way that we are dedicated to patent and trademark. But unlike their agency, our agency has a broader mandate in that for certain things like training programs with outreach to domestic audiences and international audiences, we actually are our statute that created us and gave us authority empowers us to work in all areas of intellectual property. So that includes not only patents and trademarks, but also trade secrets and copyrights and other kinds of intellectual property matters. So that's why, although we have, I think, 13,000 employees in the Patent and Trademark Office, probably the vast majority, or definitely the vast majority, work on patents and trademarks. But we do have a small group, a dedicated group of people that work on copyrights, and that would include me. And I work closely with my colleagues in the interagency and with the U.S. Copyright Office, who handle some other more day-to-day issues with registration of copyrights. And so I'm familiar with all aspects of the copyright system. So I just want to kind of give that background out of the way. So I think what I'll do is probably try to give a very high-level, quick introduction to copyrights and then quickly get into fair use and using copyrighted material. So, you probably are very familiar with copyrighted materials in that copyright is a intellectual property law that protects creative expression. So it's a lot of the things, entertainment things, information things that we all enjoy every day. Anything you watch streaming on Netflix or listen to Spotify, or you go into a museum and look at nice paintings or photographs. That's all within the subject matter that is protected by copyright law. So the creators, the people that actually, the artists, the creators, those who write books or paint something or sculpt something or put pen to paper and create movies and play music and perform music and record music. That's all. Those are all the creators that we're talking about as it relates to copyright law. And once they've produced their creative expression, their creative works that the public can enjoy, that they want to put out there in different settings. So, for example, like I said earlier, you could either, an artist or a painter or a photographer could, work with an art gallery and actually have exhibits of their work, and then you could go to a museum and see it. But obviously, we're talking about probably more convenient to a lot of us is the a recording artist or a movie studio that's produced something, and then what they've done in terms of trying to make their works accessible and available to the public is they contract with media distribution services like Spotify, like Pandora, like Netflix, HBO, Disney Plus, all those kind of digital media providers that then make those creators' contents available to the public either through free or through an advertising model or through subscription based or however it might be, and it can be online streaming downloads, that kind of thing, or it could be physical media, like I don't know if people still buy DVDs, or CDs, or certainly vinyl records is coming back. But the point is that there's many different ways in which copyright owners, copyright creators, are trying to get their works out to the public for them to, enjoy or to listen to or learn or be entertained by. So copyright law, though, protects these creators' rights with respect to the things that they made. Because if you're a musician, you're a filmmaker, you create these products, you're an author, you write a book, and you put it out there for sale, and someone takes it and then copies it without your permission, and makes many copies and distributes it online or puts it on some sort of unauthorized website for anyone who can download for free, even though it's really you as an author, you as a creator want to try to make sure that you have control over who is getting it, and maybe you are entitled to being compensated for someone using your work, because that's all within the scope of the copyright right, is to give the creator the legal right to have a legal protection over their work, so that some third party, the public, who wants to use your work, generally speaking, has to get affirmative permission, or and as part of that permission, potentially pay a license fee, some sort of money in exchange for being able to access it. So again, that's very common. Like we don't go steal music or steal movies or whatever. We generally are subscribe to things that we allow us access to that material lawfully, or we watch advertisements that support a free site or whatever it might be. But the point is that the creator of these works has some control over who gets to see their work and how much they're and to ensure that they're being fairly compensated. So that's kind of the story behind from the creation side of copyright owners, and what copyright law provides. One more thing I'll say is that copyright law provides exclusive rights, a grant of exclusive rights, legal rights to the copyright owner to control certain activities like copying things, distributing things, selling things, or performing things or displaying things. So meaning like their work, if they want to provide that to the public can't go and photocopy it many times without permission or paying some sort of license. They can't, duplicate a CD many times and then try to resell that CD, whatever it might be, because that would all be violations of the exclusive right of those activities that is granted to the copyright holder under the copyright law. Okay, so I went through that pretty quickly, but I hope that's kind of clear as far as it's a property right. It's the person that created it has control over something. Now, where that comes into play with respect to the public, generally speaking, just because something is available online, especially if it's on the internet, you find it online through a Google search and it's on some website, and you're like, oh, look, here's, some movie that they have available for streaming, or I can download it, or I can find this MP3 file and of a music and let me copy it and send it to my friends. Just because you find it online and it's like public or free or something like that where you can get to it does not mean it's actually authorized and that the copyright owner is allows you to do that. That is so what my point is, that just because you have access to it does not automatically means it's available for free or that you can do whatever you want with it. In fact, it's almost certainly the opposite, which is that you should be wary of that. And the way the copyright law works, you almost have to think about where you're finding the material. It's one thing if you're on Disney Plus or Max.gov or Hulu or whatever, Max.com or Hulu, and you're watching something, fine. You presumably paid for access, and so you can watch it. Maybe you can even download it offline for your own personal use. But if you take a further step of somehow, I don't know, finding some sort of software somewhere that lets you take off some of the rights protections from that material so that you can share it with people that don't have a subscription to those media services, then you are taking steps that are violating the right holder involved in providing that music, that piece of film or TV program or whatever. And so and those kind of actions have consequences, because if you violate the rights of a copyright holder, you're potentially liable for a host of a range of damages. You can actually be sued in a lawsuit for what's called copyright infringement. It's a violation of the copyright owner's rights, and that kind of a lawsuit against you can be significant, not only because you would be facing litigation, you'd have to pay to defend yourself, but if you were found guilty of actually using something or copying something, distributing something, selling something without the permission of the original copyright owner, you could, the judge in this case could say, well, whether or not you had good intentions or whatever, the fact is that you did this, and we can potentially slap you with, or the court could order you to pay certain damages to the rights holder that are actually fairly significant. So those are scenarios we want to try to avoid. and I don't know how, some of you, especially may or may not remember this. I remember it, but back in the very early stages of the internet, and a lot of this digital technology, this is even predates smartphones. A lot of college kids and other people were doing things like file sharing of music. They were using things called Napster. I mean, all these services where you could suddenly get free music. And this is admittedly a before more legitimate and affordable subscription services like Spotify or Apple Music or Amazon Prime or whatever music was made available. And so you had kind of a disconnect where the marketplace for legitimate access to this material had not yet quite caught up with the unauthorized, the pirated sources of this kind of material through a service like Napster. And so back then, and this is now, I'm dating myself, but over 20 years ago, but back then, we did have a situation where the recording industry of America, record labels of these recording artists were suing college kids, were suing old people. I don't know. They were just suing whoever they could because they were trying to really just send a message that this kind of activity was not permissible. That just because it's freely shared and you're not making money, you're not selling to someone, and people think that that's okay. It's not. It's still a violation of copyright law, and there are potentially consequences. So, I mean, so I'm trying to set out, I think, just kind of as a baseline. I mean, it's kind of a idea that first, that just because something is available online that you find doesn't mean you automatically can do a right click, download it, save it, and reuse it however you see fit. Whether that's posting on your personal website, posting up on Facebook, or up to YouTube, or whatever. No, in fact, it's probably the opposite, which is your first instinct should be that I need to ensure that I'm allowed to do what I'm about to do. And either that is through, and if you really want to do those things, especially if it's like something that you want to do as part of your business or something like that, you're like, oh, let me find different creative artwork or visual images online and put it into a PowerPoint that I'm going to use for my business or start like putting on advertisement or something like that, but I found it online. You need to do your homework as far as like seeking the appropriate clearances of the rights, contacting hopefully whoever is the owner of those images, those those movie clips, video clips or whatever it might be, and actually saying, hey, I'm interested in using this material for X purpose. Do I have your permission? Is there like a license fee or some other kind of arrangement, contractual arrangement where you give me affirmative permission to do what I'm proposing to do in exchange for me paying you a certain fee? And that exchange, that express permission granted and potentially even money that you pay over is what will insulate you from a charge of infringement, because you're not going to be liable for something that you have a legally given grant of permission to do. So so that's kind of the first takeaway. Again, something that's online is not just automatically just for the taking. Definitely not. There are also, but I will say there are some websites, and you need to kind of be careful with where they are, but there are some websites that actually promote material on their websites that are what's called either public domain images or license-free images, okay? Or they have what's called a Creative Commons license. And these are all things that where the creators of the particular images, photos, illustrations, music, whatever it might be, have actually decided that they want more public access to their material and are kind of waiving their right to object to people using it, or even waiving their right to demand to be paid, because they actually, want to have people to just use it however they see fit. And if they want to do that affirmatively, then they will put on, associate with their particular creations, a very liberal license, like a Creative Commons license or some other kind of thing, where they even disclaim copyright, where it says, you know what, I'm just giving up copyright. I don't even care. I created this for my own, in my own interest and for the public good, and I just want to give it to the public. And if that's the case, then there are some websites that have, and I've used some of these, that have like images that are license free, and they're like kind of like stock photos or something like that. And those, at the outset usually say, and hopefully are pretty clear, that like these are free to use, and and you will not be liable from the rights holder, because the rights holder has given everyone permission in advance. And so that's something you could try to seek out, to the extent you're looking for, certain audio clips or video clips or pictures. But I will also say that one problem is sometimes I've seen is some websites that try to say, that use disclaimers to say like, I have no rights to this material. I'm posting it here. I'm giving attribution to the person that made it, but and then tries to try to kind of say, well, don't blame me or something like that. And I would say that just by putting up there any kind of disclaimers or saying like this is a non-profit or non-commercial website, and you're something like that, that does not absolve or eliminate the need, generally speaking, to seek affirmative permission, affirmative license to use something that you find online. Okay, so that is kind of the baseline. Now, there is something called fair use in copyright law. And what fair use is, it's a what's called a limitation or an exception to copyright owner's rights. Okay, so everything earlier I told you, like copyright owner has all these exclusive rights to control certain things. Well, fair use is an example of one of a provision in copyright law that says that the public can actually use certain material that is copyright protected by copyright, but they're allowed to use it without getting a license, or without getting affirmative permission, without paying anything, as long as it's under certain limited circumstances. And this is kind of a very difficult concept to understand, because the way fair use works is it's it's unfortunately something that is very fact specific, and it determines and it's very much turns on a lot of what you're doing and your intent for things and how much you did of something in order to determine whether or not it's covered by a fair use exception. Okay. And fair use is also in the legal sense, it's what's called an affirmative defense to an infringement claim. So basically, if you were doing something with something you found online, and then you get contacted by the rights holder and says, "Oh, I'm going to sue you." One of the things you can try to say in defense to raise is fair use, that what I did was protected by fair use. And if the court in the lawsuit agrees with your claim of fair use, after you've proven all the different things, and I can talk about that in a second, as to why you think your particular behavior, your activities, what you've done with the copyright work falls within the fair use defense or the fair use exception, then you will be held not liable for copyright infringement, and the copyright holder can't stop you, won't get money, and you won't have to pay anything. You're not going to be fined or whatever it might be. You're covered by fair use. All right. And the copyright law actually codified fair use in a particular statutory provision of the U.S. Code. It's Title 17 U.S. Code Section 107. And what it basically says is that someone can use a copyright work without the owner's permission, the original creator, for certain purposes, such as, and the statute lists these purposes as examples, such as for criticism, comment, news reporting, teaching, scholarship, or research. Okay. Now, the problem is that these are very broad categories or types of activities that unfortunately does not mean that you can just say, "Oh, hi, I was in this classroom, I'm a teacher, and I'm going to show the entirety of this movie to my entire class because it's within the scope of my class teaching activity." That does not work. Like, that's not good enough. Like, yes, it's true, you are a teacher, but that doesn't give you automatic permission to use anything you want. All right. And or I'm a news reporter and I'm going to show on the evening news this entire, or play this entire song from this artist, right, or performing artist. Those categories that I mentioned earlier are just illustrative examples of some things that might be considered fair use, but then it depends on the very specific facts of the activity and what you're doing with it. And I'm sorry that this is kind of hard to explain, but fair use is probably the most difficult concept to understand in copyright law, and it's probably the most litigated thing, because almost everyone that's ever accused of copyright infringement raises the defense of fair use. And so it's constantly litigated about whether or not something you did actually falls in or out of the scope of fair use. And the statute I mentioned earlier, the copyright provision 17 USC 107, lists 4 particular factors that a judge has to look at as part of the fair use analysis. And they look at 4 things, and I'll list them quickly. One is what's called the purpose and the character of your use, including whether what you're doing is commercial in nature, what you did with the copyright work of somebody else, whether or not you're doing it for profit, or whether or not it's for some sort of nonprofit educational purpose. So those are factors that fall into this first factor of purpose and nature of what you did. So that's what they will look at and consider. The second factor is called the nature of the copyright work. So, for example, if the copyright work in question is very artistic in nature, very, very creative in nature, it's a piece of artwork, or something very generally speaking, the court will be more protective of that material and say that that's not a fair use of that. But if, for example, because copyright protects computer code, for example, and computer code can be functional, or it is functional, and so or a news article that conveys a lot of factual information, which is not, facts aren't protected by copyright. And so depending on what you're doing with that particular material, the nature of that copyrighted work will influence whether or not it's fair or not. The third statutory factor that a court looks at is what's called the amount and substantiality of the portion that you used in relationship to the whole. And what that means is just simply how much did you use? So if you took an entire textbook and you photocopy one page of the entire textbook, it's a very small amount, right? And so it weighs in favor of fair use as opposed to you copy the entire thing. Okay. On the other hand, if you just copy one little part, if you took out a little clip of a movie, but it's like the most important part of the movie, it's like the pivotal thing where the guy says Rosebud or whatever, then that potentially, even though it's a small amount of the entire movie, if it's very significant, it could factor against you in a finding of fair use. The fourth factor is a very important factor. All four factors are important, and there's no necessary weight to each one. They're all considered evenly balanced, or at least a court's supposed to evenly consider them. But the fourth factor is called the effect of the use upon the potential market or the value of the copyrighted copyrighted work. So, for example, certainly if I buy a Taylor Swift CD, and then I take it home and I make all these duplicates of it and I like sell them or give away to my friends. Well, that will impact the market for other people, for this recording artist, because she's losing sales, right? I mean, someone's not buying it if they've got it for free from somewhere else. So that is a potential impact. My activity in unauthorized copying, unauthorized distribution of a copyrighted work affects the creator's ability to profit off of their work, right? And so these four factors are taken into consideration by a court in evaluating any fair use claim. And so it's tricky because what you're doing, it's almost like you won't know definitively if what you're doing is fair use and you're totally in the clear until you're actually sued, and a court will look at it and say, yes, this is fair use or it's not fair use. Now, the good news is that the U.S. Copyright Office on its website, and you can Google this, but the U.S. Copyright Office has what's called a fair use index. And what they've done is they've compiled all the fair use cases in all the various courts around the United States that have discussed different fact patterns and said this is a fair use or this is not. And so that kind of gives you some guidance. And they also have it's a pretty user-friendly website where you can like check off different boxes to say, well, I'm thinking about using this particular music or a piece of art or some image file off the internet, and I'm doing it for this purpose of teaching or for whatever it might be. Then it will pull back and show you case law, case summaries of court decisions that have looked at that kind of scenario and have rendered a decision about whether or not it's fair or not. So that will give you kind of an idea, because generally speaking, it's precedential. So if what you're doing is very similar to what someone else did that had been previously found to be fair use or found not to be fair use, that'll kind of give you some idea as to whether or not what you're doing might fall within. But I would say that generally speaking, just because fair use is kind of a amorphous thing that's not very definite, if you are very concerned about your legal liability, it's always better to try to get affirmative permission to use something from the copyright holder. And and depending on who you're asking, they may very well easily give you permission, even just a written permission over email, being like, that's fine with me. We're not necessarily looking at a $500 license or more. I don't know. It just kind of depends. But at the same time, if you're saying, oh, I want to use the latest Batman movie and a clip of that, well, then okay, they'll probably charge you. So those are the kind of things that that you need to kind of take in consideration as you evaluate using copyrighted works, copyrighted creative material that you have access to, that you even own. Like let's you as I gave the example of, you lawfully bought a DVD, a movie, a copy of a movie, or you lawfully downloaded something that you purchased, an MP3 or a movie file. But ownership does not grant you the rights of the copyright owner. So that doesn't mean you own it, but then suddenly you can do anything you want with it. I can copy it many times. I can, print it out many times, whatever it might be. No, those, unfortunately, the rights remain with the copyright owner, even though you own a physical manifestation of what they've created. That's just your copy. So anyway, so that's a very quick overview, I think, of copyright as it relates to fair use and the use of materials online. And I'm very happy to now engage in a question and answer session. If anyone has specific scenarios or questions about fair use or any of the things that I've just discussed, or anything I haven't discussed and you're just curious about, I'm happy to do that.
So Brian, I'll jump in. Megan, who is one of our communication fellows, dropped a question in the chat. I'm guessing relating to the fact that we are planning to put out some interviews and podcasts while we're at convention. And so she asked, for someone being interviewed for audio and video, what does one need to do to cover our liability? And
it's also selfish. I'll put it out there because
okay,
I also have a podcast, and I'm wondering the question about when you do an audio and video recording of somebody, what's the liability there for copyright?
Yeah. So that is actually not really a copyright concern.
Oh,
because no. But let me explain how this works. Because if you are the one that created the audio, the podcast, you're producing the podcast, you're providing the equipment to record it, the video and the audio synchronization, whatever it might be, and you're talking and the other person's talking, you are actually the copyright owner of that audiovisual product. Okay. And the subject matter of that product does not have a copyright interest. Okay. So let me put it to you another way. If I'm in public and I take, like, I'm just on the street and I take a picture of somebody over here or a building or whatever it might be, I take a picture, I'm the photographer, I own the rights to it. And the subject of that photograph does not have a copyright in the photograph. It's the photographer. Same thing here with filmmakers or with podcasters. It's you who's producing it has the copyright interest. Now, where you may be needing to cover yourself is in terms of certain speaker clearances, as far as getting the person you're interviewing their affirmative permission, to have their voice and their likeness, their image, like, recorded. Okay.
Yeah.
And that's the kind of thing where that's not a copyright law thing. It's more of a state law thing where, some people can sue for, it's kind of like a right of privacy kind of thing. Right.
Right.
And so that's where, through certain releases that you would have, that's where you get it from them, but it's not a copyright thing. So they can't stop you from using that recording that you've made of, that they've willingly, presumably willingly accepted to be interviewed. Then, and as part of that agreement, you inform them that this is what I'm going to do with this recording. I'm going to put it out there on a podcast platform or on a website for the public to, and it's their choice at that point whether or not to agree to even do the interview. But once they've done that, they lose a copyright interest. It's your copyrighted work.
So once a release, Phil, just for us too, for the comms fellow, once a release is signed, we then own the property. Like, we own the intellectual rights to that, whatever that is, whether that's an audio file or a video. That is then the copyright ownership of the person who's producing that. They have no right to come back in the future and request compensation, or I guess
that's right. I mean, I don't believe so. Now, the only way it might come into play is under, again, it's not a copyright thing, but it's more like a state law right of what's called publicity, where, like, let's say, I mean, I don't know if this really happened, but you interviewed somebody, and then as part of that process of having that recording, you promote it widely, you start selling copies of it, or you try to manipulate that recording somehow to suggest that person's, like, endorsing you, or you're using that to sell something. All those things are starting to encroach on state law rights that are given to individuals. I mean, it's usually in the case of celebrities, honestly, where, like, you can't just say, oh, all of a sudden this someone gave this interview and then now we think that this really famous person really likes this product, and if they're using anyway. But I mean, I don't know that it's strictly limited to celebrities. I'm not as familiar with that area of law, but it's not copyright. But that is at least one potential concern, and that's where having upfront, the appropriate releases that have the kind of legalese language that says, like, you either consent to us using this in the future, and in these manners. And so it might bind yourself too, to the extent you're saying, we agree not to use it in a commercial fashion, whatever it might be.
Yeah.
And so for us, we have it as part of our general registration for convention,
Mm.
a rights waiver saying by being at convention, you agree that you might be photographed, you might be recorded, you might be seen, and for promotion of Grange purposes and Grange purposes only will that be used. So that kind of covers us and protects us as well as the people there, knowing that we're not going to be selling their likeness to some random company selling shoes because we caught their shoes in a video. So yeah. Any other questions from anybody?
So one thing I just want to jump in and just say is that a lot of like social media platforms, like your Facebooks or YouTubes or whatever it might be, they have as part of the their license agreements and what's called um, user agreements. When you sign up for an account, you know, you've got to like click through like this really long list of terms and service, whatever. But in there, it tells you there's almost certainly some sort of intellectual property clause that talks about what kind of rights that you're either retaining or potentially giving up, or at least giving a limited license or a non-exclusive license back to the platform that is allowing you to upload whatever the thing you are that you want to then promote or give to the public or share with your friends or whatever it might be. And so those kind of conditions, those legal terms of service, definitely do factor in with respect to, you know, what are the rights of somebody that is creating something, uploading it, or someone who's just a user of the particular service and is viewing something or wants to do something further with it. So potentially what I'm saying is that if you download something off of YouTube or you right click an image off of Facebook, whatever, you may or may not be liable for copyright infringement, and you may or may not, your actions may not be covered by fair use, but depending on what you're doing, you could be in violation of the service provider's contractual terms, and you could be then potentially sued for breach of contract, which is a state law thing, because you've violated what you agreed that you would do or not do as part of you exchanging to join the service, to subscribe or sign up for, set up a profile. And so breach of contract would potentially subject you to a termination of your account. And so these are the things that have nothing to do with copyright, but just have other legal ramifications that you're not playing by the rules set up by that particular media platform.
And I'm going to chime in, tagging right off of that, Brian, is that copying and pasting something you see on Facebook that says you did not give Facebook the right to use or the ownership of your photos, that doesn't work because you already signed off on it. I see that going around, you know, every couple months or so, like it's official as of today, Meta owns everything. Well, they do.
Yeah. Well, and that's kind of, I mean, well, unfortunately, but that's also people's choice. It's a
Right.
voluntary choice to use their platform.
So
that's why a lot of people leave, because they don't like those terms. But some people, you know, really still want it and are okay with it. Well, you know, one other thing I was just going to briefly mention, I did kind of mention this offhand, but it was something called the public domain, which I did mention earlier. I don't know how if people understand what that is, but basically, public domain means creative material that is no longer protected by copyright, or that is not copyrightable material that's just available for anyone to use without need to get a license or get permission or anything like that. So usually in that case, it's like very old books, very, very old paintings and old recordings, old films. Those are all things that fell into a public domain, and the public domain, as I said, anyone can just use it. So there are some websites that just have all public domain books, public domain images available for anyone to use. And so that is outside of copyright. It's part of copyright in the sense that it's material that's no longer copyrightable or copyrighted.
So Brian, we have a question from Elizabeth, actually. It says, can you address something I have commonly heard? Namely, is it sufficient to simply acknowledge the source of an image, i.e. name the photographer without going the extra step of getting their permission?
Right. Okay. No, that's a great question. Actually, I should say, I probably should have done this, but like there in my more formal like presentations that are like 2 hours long or whatever, and I go through things at the very end, I have kind of like a FAQ, kind of like fact or fiction or top 10 myths of copyright. And this is definitely one of those myths where it's not true, because some people think that you're right, that like, oh, well, I can still use it as long as I give credit, right? Like I because it shows that either I'm doing it in good faith, that I'm not I'm innocent or that I'm not intentionally trying to violate your rights, because I know who owns this, and I'm going to say that this is not my work, it's this other person's work. And I'm just going to give them their little byline or the credit beforehand, a little notice. Unfortunately, that does not work. It does not substitute for getting permission, and you can still definitely be sued, just because. And so that's why I've seen some of those websites that try to do that, and definitely they are not legitimate.
So I work, hi, sorry, Brianna here. I work in the event industry, and I do have a lot of event coordinators that will send over like the galleries that the photographers did,
Mhm.
and they are allowing, and they, in the emails, they typically say that the photographer will allow us to use it for marketing purposes
Yes.
as long as we credit them. So is
Okay.
that bypass, like that's
Yes.
essentially
No,
them
that's
giving us
fine, because
copyright? Okay.
no, exactly. I mean, or they're giving you a limited right to reproduce or reuse for something. So yes. So that's an example
Okay.
where the right holder, the photographer in question, is saying they're in control. They're telling you, yes, you're allowed to use it in this way.
Okay.
So that's totally fine. But they place a condition where they're saying, and you must give me credit. But if you are on your own just wanting to give someone credit and thinking that will be, no, then that definitely does not work. I will
Okay.
also say that the other thing that I've seen is that, well, I should say, is like any kind of violation of law, like if you run a traffic light or you don't fully stop at a stop sign, whatever, they're all technically violations of law, right? And you are technically maybe guilty of, infringing a law, or doing something unlawful. But unless someone complains about it, either you're pulled over or you've got a, stoplight camera or something like that that actually sends you an image that says I busted you. um Unless that happens, there's not really a real world consequence, right? I mean, oh, I guess you kind of got away with it. Same thing here with like infringing materials or infringing someone's copyright rights. It's the onus, the responsibility is on the right holder to monitor the uses of their work. And if they find out that someone is using it without their authorization, then they can take steps, if they choose, to enforce their rights and say, stop doing that. Or they might find out someone's doing something and they didn't give them permission, they didn't, pay them license, but what the person is doing is like this little kid who's like just doing it for fun and they're getting lots of hits or whatever. They might be like, that's fine, and they just won't choose to sue. And that's within the rights of a copyright holder as well, is to decide when and where and how to enforce their rights. So again, all of us are probably infringing a lot of copyrights all the time, but unless someone kind of finds out about it and complains and is upset and lets you know about it, there's not really a consequence. But if you're a business owner, there is definitely like a risk tolerance where you may not want to like risk that, depending on how public you are or how much you're doing something. And that's when you definitely want to keep your risk to a minimum, legal liability to a minimum as it relates to the intellectual property. You want to try to respect all the rights of creators for their hard work, and as a matter of fairness and so forth. So you have to make sure you get the correct licenses, pay the correct fees, whatever it might be, in order to use it in a lawful manner. So I kind of say that just as a side, just so because I'm sure I violated copyrights on occasion, and I'm a copyright lawyer. But I mean, there's definitely some of that you kind of have to kind of keep in mind with respect to calibrate, what you're doing. And actually, as it relates to Brianna's question about the photographer, there are definitely things like photographer, like wedding photographers and so forth, where you're contracting with them to do something for you as a service, where you're hiring them, they're taking the pictures, but they're the photographer who has the equipment, who took the photos, they have the artistic vision to get the right lighting, whatever. So they own the copyright to that material. But then, as part of the contract for you hiring that vendor, that photographer, they will often give you certain limited licenses to do, because the photos are for you. I mean, that's the whole point. So you will get like disc or MP3 files of I'm sorry, digital files of the photos for you to use in a certain manner, as long as it's within the scope of what the photographer allows you to do. Okay. But there are other situations where, if, like, let's say you're a employer and you have your employees doing stuff for your business. Okay, so they're writing things that are going to be published on your website. That they're producing articles, producing artwork, whatever it might be. That is part of their job duties, and it's what they're being paid for, and it's for in service to the company. The person that actually wrote that down or took the picture or whatever it might be, illustrated something, they're not the copyright owner. In that case, it's the company that's the copyright owner. That's what's called the work made for hire doctrine, and that's a principle in copyright law that just basically says, because usually the general default rule in copyright law is the copyright owner, the copyright rights holder, is the person that actually put pen to paper, that actually created the thing. But in a business setting where there's an employee and employer, then that's an example where the employee can't just say, oh, I made this thing for work and now suddenly I can go find a publisher to publish it, whatever. No, actually the company owns that. So that's an example where the ownership of the copyright goes to the person that's actually paying for the materials and commissioning the work. Are there any other questions I can answer about this topic? And it's a very a broad topic, and I think definitely with the internet and everything, there's just so many more things that could potentially be used out there. And anyway,
I think you've done a thorough job of the high level stuff tonight. I know there's some nitty gritty that we could easily get into when it comes to that kind of stuff, but I think that if nobody else has anything, nobody seems to be chomping at the bit to ask questions right now.
I will also say that there's a couple websites out there that are run by like university libraries, and a couple from that I know from Stanford University, and some other places like associations that represent a lot of copyright holders, like the Copyright Alliance. A lot of their websites have dedicated like fair use sub pages or web pages that provide definitely advice and tips about whether something you're going to do may or may not be fair use. They even have like a fair use predictor or something like that, or even things where you can type in different things and an algorithm might kind of give you a sense of whether or not what you're doing is more likely to be fair or not. So I would kind of go out there and see if you can use those kind of tools. They might be helpful to you.
Yes, Megan.
Sorry, one more question. Just thinking about some stuff. So when you create or when, let's say like graphic design or graphic design like light, like let's say you're using images from like Canva is the first thing that comes to mind. What are the copyright implications with using images that are like, and let's say like I pay for my subscription to Canva, so I have access to those images and I put them together in a way that's my creation, quote unquote. Right?
Yeah.
And then I produce it, whether that's for sale or just for promotion or whatever. Is there copyright around that?
Yeah. So, this is where I need some more information from you. What is that? Is that a software program or a website?
Okay, it's an online software, but it's like it's like a design studio, but it's like I call it graphic design light. Like you're not making images, like you're pulling images from like a clip art file, that sort of thing. And they've got templates, which are they're free domained templates that people have made and then put back onto Canva.
Yeah.
But the question is if I change it and put my own.
Yeah. That's a very good question. It's a little hard to answer, but I will say this, that it kind of depends on definitely the terms of service of that website. And I'm sure that they've kind of explained exactly what can be copyrighted. But to the extent it's using like either public domain materials or other kind of things that are Creative Commons license or whatever it might be, if you are assembling and deciding, different variations of patterns of like where you want to put things, copyright law actually does protect a creative way of arranging things, creative choices that you make in selecting things, and that is what's called like a compilation copyright, where you could potentially get copyright protection for the overall product of something that individual things within it may not be copyrightable or may longer be protected by copyright, but the way in which you did it is very different and interesting, and you will get a copyright to the extent that it reflects your creative decisions. You know, I'm kind of being vague there, but it is something where, you know, you may not, you can't claim a copyright in the underlying piece of art that is in the public domain, you know, just because you used it. But if you use it in a way you mashed it up and you put it through, you know, very, then potentially it covers the entirety of the way in which you arranged and selected and you know, chose to display that thing. So, yeah.
Awesome. Thank you.
Sure, no problem. And one last thing I'll just say, just because I'm reluctant to say it, but as you probably all know about artificial intelligence, and everyone's using these things called generative AI and Chat GPT and these like Dolly and all these kind of things that allow you to just type in words and it creates like whole like paragraphs of text, or you know, or creates a whole new piece of artwork. That right now is a very, very hot and controversial and contentious and unresolved issue in copyright law as to whether or not that kind of stuff is copyrightable. So we at the USPTO don't have a position. U.S. government doesn't have a position because it's something that is in the very much right now. Just it's such a hot topic, and everybody's engaging in talking about this technology. The technology is changing so rapidly. So you know, we've had some guidance about some of this already from the U.S. Copyright Office, as well as some studies that we've been working on with them, where, you know, generally speaking, something that's purely AI generated is not copyrightable because you need to have like human, significant human authorship, significant human input into something in order to protect it under copyright law. But there are a lot of other questions about like how AI generated works interacts with copyright holders' rights and a lot of things. So it's definitely something that we're trying to make our, you know, it's very hotly debated right now. It's probably the key issue right now in copyright law among copyright scholars and practitioners. So I'm kind of glad we didn't go there because the answer is I don't know. One final thing, I'll give a plug to the USPTO's website for this, but you know, everything we've talked about today is about copyright, but obviously earlier I talked about patent and trademark as other types of intellectual property, and the U.S. Patent and Trademark Office has a tool on its website that allows any member of the public to kind of use that. You will be able to input in the information about what you're trying to do and what you'd like to do as part of your business. And then it will tell you what kind of intellectual property right is likely available. So if you're talking about, oh, I want to protect my business's logo and name, well, then that's a trademark. If you're saying, oh, I've got this really great idea for some invention or discovery, well, then that's a patent and so forth. Pete, you have a question?
I do actually. This is more for Sahar and Elizabeth, since they'll be coming to National Grange session. I appreciate, Brian, what you've given us tonight, because I think it's opened my eyes a little bit and some concern, shall we say. So I assume the ladies are going to bring, Elizabeth's sharing a lot of great websites and different pages. Are you going to bring some of that information so we could start fostering conversations with the individuals coming to national session? I mean, that's how I see it. Is I think it's an opportunity for people to ask one-on-one questions.
Certainly, Pete, and that's part of our being there is we do welcome the opportunity to bring both hard copy materials as well as to do one-on-one consultations there in the exhibit hall to engage with attendees. We love that opportunity to get out into the community and have those conversations. We will paper the exhibit hall with government paper because we're super good at it. It's our best party favor that we bring along with us. So we're really looking forward to it. We have a lot of literature, brochures, information, and happy to share all of that. But again, happy to also engage one-on-one.
Excellent. Phil will tell you that I'm a question guy, and one question usually leads to another question. And I think it's going to be a great opportunity to point Granges and Grange members towards your office, which I'm tickled to death y'all is going to be there. I really am.
Thank you. Thank you for the kind invitation.
It might take them a little while to get warmed up, but once they get started, they'll keep going. So thank you.
Only
look
have
forward to it.
45 minutes, Pete. So
Hey, be good, Phil. You know me.
Well, I do want to jump in here and say thank you to Brian for all the great information. Thank you to Elizabeth and Sahar and Anna. And I also saw Tamika popped on. Thank you all for being here tonight from the USPTO. This was great information. Definitely we'll be sharing it with our members. By the way, this is me asking for permission to share the video, although you guys knew it was being recorded. But I really appreciate your time tonight. And like we said, Elizabeth and Sahar will be coming to Niagara Falls. They'll be presenting on Thursday, the 16th at 9:30 a.m. We'll be in some room. I think we're in the governor room in the Niagara Falls Expo Center. So please, if you're there for convention, come and take part in what's sure to be a great continuation of this and diving into some other patent and trademark issues. Of course, we at the Grange are very familiar with protecting our trademark. So we are deep into those conversations quite often. So thank you guys. And if anybody else has any questions, now's your chance.
I just wanted to say that we'll also have a booth at the conference, so please stop by.
They will be in the showcase in the cataract room. So be sure to pop in over there. It's going to be a fantastic display room this year. So they'll be among many partners that we have coming this year. Loretta, do you have a plug to drop in for National Convention by chance?
Let me think about, oh, yes, I do. The plug is bring a little extra cash because we are selling Grange socks with the Grange logo. So I'm hoping that maybe Elizabeth and others would like to buy a pair of Grange socks as your very first Grange item while you're at convention. We are very excited of having you all at convention. I'm looking forward to seeing a lot of these smiling faces tonight at convention. So it's going to be a convention like no other. It's going to be a fabulous convention, and we are looking forward to it.
Great. So to sign up for convention, if you haven't yet, it's grange.biz/convention with a capital C 157. And that will get you right into our registration page. Thank you all for being here for our communications Zoom-torial. I do want to put in a plug for all of our staff members that we are approaching convention season. So if you're reaching out to us at the national level, please give us a little extra grace and a little extra time to respond. So thank you again to our guests tonight. I really appreciate you all being on. And please let anybody who wanted to be here tonight that you know of that couldn't tune in, this will be up on our YouTube channel, youtube.com/nationalgrange in just a few days. So thank you all again. Have a great night.